Good afternoon, everyone. I guess I should gavel in. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as anyone in Las Vegas or anyone watching through our YouTube legislative channel or through Nellis. And with that, Committee Secretary, please take the roll.
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Orentlicker, Roth, Urick, Chair Miller.
Here, thank you so much. With that, I just want to address some housekeeping issues. Of course, I ask that everyone turn down the volume on any of their electronic devices so that we don't disrupt today's meeting. I would also like to say that I know there's been a lot of questions about me announcing that this was an informational meeting. That is only because the bill is still being reprinted. So because of that, it is sine die, and we did not want to wait any longer. But this meeting will have all the same components of any other traditional hearing. We, as everyone else out there in the audience, all of you that are watching right now, are working off of the amendment that was, like everyone else, the amendment that's printed on Nellis. With that, today's hearing, we will have, again, like always, just a few reminders, asking everyone who speaks today to please make sure that you state your name and spell it the first time that you speak for the record, whether you are presenting the bill or testifying or making public comment. With that, each time you speak as you're presenting, please make sure that you restate your name again. I will provide the phone number right now for anyone that will be participating, again, that's testifying or making public comment over the phone. The phone number today is 669-900-6833. The meeting ID number is 859-733-10245. The way that today's hearing will go is that we will have a 20-minute presentation. We will also have a 10-minute opposition presentation. Testimony in support will be 30 minutes. Testimony in opposition will be 30 minutes, and testimony in neutral will be 30 minutes. Again, I will remind you when we get to the testimony portion, we ask that everyone making public comment or testifying on the bill keep their comments to 2 minutes. I will remind you later that, again, it's always okay to say ditto or that you agree, because the quicker we can go through gives just that many more people the opportunity to provide their position on the bill. Again, members, I trust that you all have the amendments that we will be working off of. And with that, I will go ahead and open the hearing on Senate Bill 457. So I will welcome the presenters up. Your hearing is open, so whenever you're ready, please proceed.
Thank you, Chair Miller, and good afternoon to you and the Vice Chair and members of the the Assembly Judiciary Committee. My name is Jennifer Noble, Jennifer-Noble, and I am here on behalf of the Nevada District Attorneys Association to present to you Senate Bill 457 and to go through the bill as it is now after Amendment 986 has been incorporated. So I'll go through those provisions as efficiently as I can, and then Lieutenant Jason Woodard is here to help answer any questions that the committee may have. I'll note that the following sections have been deleted from the bill. Sections 1, Sections 5 through 29, Sections 33, 34, 37, 39, 76, 78, 79, 83, and 84, Section 54, Sections 59 and 60, Section 73, Sections 78 and 79. Section 1.5 of the bill with the amendment incorporated, defines an agency which provides child welfare services. Section 2 updates and strengthens Nevada's stalking laws. Section 2, sub 11A includes accessing a social media account of the victim, their family member, or a person with whom they have a dating relationship as an act that may be part of a stalker's course of conduct. 211B revises the term course of conduct to include 2 or more acts conducted in person or by electronic means. 211D revises the definition applicable to what is commonly known as cyberstalking to include social media communications and similar means used to electronically publish, display, or distribute information. 211I defines social media communication to include private messaging on a social media platform or communication shared on a social media platform visible to users. Section 3 of the bill changes the unit of prosecution for possession of child pornography. In Castaneda versus State, the Nevada Supreme Court recognized the important policy goal of tying punishment for possession of child pornography to the victimization of each child. But it also explained that under our current rubric, Nevada only allows a single count to be charged, even if the defendant has numerous depictions of children being sexually abused. Our statute prohibiting this kind of conduct should reflect that each image of a child victim represents unspeakable trauma and recognize the harm that continues to the child each time a new image is traded, obtained, or possessed. Section 3 of the bill amends current NRS 200.730 to provide that each child depicted in the images may be charged as a separate felony count. Nevada law requires courts to order convicted domestic batteries to surrender their firearms. Courts may also issue similar orders when a person is subject to an extended protective order or as a condition of pretrial release. Section 4, as amended, changes Chapter 202 to provide that offenders convicted of domestic battery who are ordered to surrender their firearms must appear for a compliance hearing within 2 to 5 business days. If the person is in custody when the order is issued, a compliance hearing must be held within 1 day of the person's release. Pursuant to the amendment, the hearing may be canceled if the person provides documentation demonstrating that the firearm has been surrendered, sold, or transferred to the court, or a search warrant has been issued, and that declaration must be under penalty of perjury. Section 29.1 creates a new crime to allow punishment for, quote, smash and grab offenses. In essence, if a person enters a retail establishment, causes property damage, and steals property, this new crime would apply if the aggregate damage and theft is over $500. Section 29.5 requires a board of county commissioners in a county whose population is 700,000 or more to adopt an ordinance that designates the boundaries of one or more corridors in which the commission of the crime poses significant risk to public safety, and it authorizes the justice courts in such counties to establish a program related to the corridors and to require reporting related to those corridors. And that actually incorporates Section 29.7, which requires the justice court who has such a program to report certain information regarding its success and the crime rates. Section 30 amends NRS Chapter 33 to provide the same compliance hearing procedures for firearms ordered to be surrendered pursuant to an extended protective order. Section 32 expands the list of felonies that may constitute domestic violence to add kidnapping, as well as attempts to commit these offenses, to the list of included felonies. As amended, conspiracy has been eliminated, and robbery has also been eliminated. Section 34.3 provides that a certificate of innocence and provision of an award in a wrongful death action is not a finding of certain wrongdoings in the investigation or prosecution, and is not a finding that there was not probable cause related to the offense. Section 34.7 changes the definition of community service for juveniles to include community-based activities that facilitate civic engagement, critical thinking, and connections to community. In 2023, there were 6,800 violent incidents in Clark County schools within a 7-month period. Children, teachers, and school employees deserve a safe and learning environment. Section 35 of the bill provides that when a student assaults or batters a school employee, juvenile courts must ensure that the student is evaluated before they can return to the community. Section 51 amends NRS Chapter 178 to include the same procedures for orders requiring the surrender of a firearm as a condition of pretrial release, as I previously described. Now, this is a little bit out of order, but Section 3.5 and 60.1 to 60.5 add language to NRS Chapter 179 to create a narrow exception to Nevada's general rule that 2 parties must consent to the recording of a telephone call. This only applies in prosecutions and investigations for child sexual assault. Nevada is one of only 10 states that do not allow for this exception. Under current law, law enforcement may be present to witness a call and to take notes for evidentiary purposes, but recording is prohibited. So the officer's testimony is based on his notes and his recollection. Sections 42 through 49 and 74 of the bill, as amended, would prohibit only the sealing of offenses of child abuse, child neglect, elder exploitation, or elder neglect for purposes of sealing only. So diversion and dismissal are still available, but they would have to be subject to the typical sealing requirements, even if they undergo a diversion program. Section 53 pertains to pretrial release, and it excludes the time calculation for the 48 hours. It excludes state holidays as defined by statute. This exemption will help ease the burden on rural prosecuting agencies and help ensure that victims have more opportunity to be heard at these hearings on the holidays. Last session, I'll note Chair Scheibel's efforts in this area resulted in additional funding for rural areas that were particularly struggling with the new requirement, which was much appreciated. Sections 55 and 56 require that any money collected from the defendant be first used to satisfy restitution before it can be applied to court fines and fees. This is consistent with victims' rights under the Nevada Constitution, often referred to as Marsy's Law. The amendment to Section 56 provides that where a person other than the defendant posts bail, those funds may not be used to satisfy restitution without prior notice and consent to that third party. Section 57 updates our immunity statutes, which have not been updated since 1967. But in 1972, the United States Supreme Court issued its decision in Castigar versus the United States, which held that the government may not compel a witness to testify without granting use immunity. 57 updates our community statutes to align with the Castigar decision and current constitutional law. Section 58 authorizes a city attorney in a county whose population is of 100,000 or less to be deputized in the county in which the city is located for the purpose of serving as a prosecuting attorney for a pretrial release hearing required on the weekend, and to authorize the city attorney to receive a stipend for that service. Section 61 requires the Nevada Department of Corrections to coordinate with the DHHS while implementing medication for opioid use disorder or MOUD programming. DHHS is responsible for ensuring that state and federal guidelines are followed in these programs and plays a central role in overseeing and coordinating statewide efforts related to the substance abuse and prevention. Section 62 provides that where funds are available, local jails shall collaborate with DHHS to establish treatment programs for opioid use disorder. Local programs are important, of course, because they allow the offender to begin treatment prior to moving on to the NDOC. Section 60.6 to 60.8, 61.3, and 61.7 allow the Nevada Department of Corrections to establish an alternative correctional program. Sections 70 and 71 require that the Department of Health and Human Services connect government agencies to training on trauma-informed practices for persons with opioid use disorder and medication-assisted treatment. Funds for Resilient Nevada may be used for training law enforcement and criminal agencies on best practices. Section 77 relates to DUI, and I'll note that in 2024, 412 people died as a result of deadly crashes on Nevada roads, and this is an increase from 2023, which is 390 deaths. The leading causes of these crashes were speeding and impaired driving. Section 77 of the bill is a cleanup provision regarding the applicability of the per se marijuana statute to felony DUI. It does not establish a new DUI penalty or theory of criminal liability, but clarifies language created by AB 400 in 2021, then it inadvertently omitted reference to some types of felony DUI, specifically DUI causing death or substantial bodily harm and vehicular homicide. Under current law, the per se does still apply to all forms of DUI, but the current statutory construction could be much clearer. The reprint removes sections 78, or not the reprint rather, but the amendment removes sections 78 and 79. Section 80 increases the penalty range for DUI causing substantial bodily harm to 2 to 20 years. For DUI causing death, where the person has a prior DUI conviction, the penalty range would be 5 to 25 years. Sections 89 and 90 provide that the Nevada Department of Corrections must go to the Interim Finance Committee to seek additional funds to implement the transitional release program. So that is your overview of the changes as I understand them, including the Amendment 986. And Lieutenant Woodard and I are here to help answer any questions.
I'm sorry, when you say the changes from what? Because this is actually the first time we were seeing it. So when it came on Nellis, the amendment, that was the first time that we saw any language. So could you explain what you're referring to?
Thank you for the question, Chair. Jennifer Noble for the record. What I'm referring to is the original version of the bill, Senate Bill 457, and I realize this is the first time it's been presented in this committee. So rather than calling it the changes, I'm just trying to note that there are, the language is different from the original bill, and what I have just endeavored to explain to the committee or go through is consistent with the current form of the bill as reflected in the amendment.
Okay, thank you. With that, we will open it up for questions, and our first question will be from Assemblymember Roth.
Thank you so much, Chair. Although I do wish I've had more time to digest this. This is sine die and the first time that I'm seeing any of this language. I'm hoping we can just kind of take a step back and look at this a little more globally, and you can walk the committee through why these changes are necessary. In 2019, we passed AB 235, and in that time, we have seen a steady decrease in crime in the state of Nevada. And that is because we made evidence-based choices in making very specific and evidence-based changes to our criminal justice statutes. And what I'm reading today is a very serious walking back of that. And so what data do you have to provide to the committee that making these very specific changes are actually going to reduce crime when we have seen both in practice and with evidence that what we did in 2019 is exactly what led to the decrease in crime in this state today?
Jennifer Noble for the record. Thank you for the question, Assemblymember Roth. So I disagree that this is a walkback of Assembly Bill 236. There were original provisions in this bill relating to the felony theft threshold. Those have all been removed. That would also include the habitual criminal enhancement and the changes to fentanyl, which would relate to drugs. Those are not included either. AB 236 had nothing to do with child pornography. So I don't see how that's a walk back. I think it's a step forward for Nevada's children. For DUI, that had nothing to do with AB 236 either. I was here during that session and worked in that bill, was in the woodshed often discussing it. So in terms of your questions about data, I don't have data to provide for you that would support the assumption that it would be appropriate to punish people who possess child pornography per child. If there are specific portions of the bill that you want data for, I'm happy to answer those one by one, but it is quite large, and I know this is sine die.
Thank you, Chair. Yeah, I mean, I know it's easy to focus on child pornography, right, because that shocks the conscience. But what we're talking about here is making serious changes to bail in this state, which we have seen has made serious improvements to our system. We're talking about lowering the theft threshold when we're talking about what you have referred to as smash and grabs to a $500. And so if you can please provide that data to the committee, I think that's really important, especially when we are receiving this in the 11th hour.
Jennifer Noble for the record. I don't say that to shock the conscience, but I do disagree with the assumption or the characterization of this as a 236 walkback. There are many provisions of this bill that don't touch upon 236. In terms of data and local law enforcement data from the north and the south, we do have that. We can provide that to the committee today. I don't have it in front of me right now. Most of these provisions have nothing to do with AB 236. And in terms of serious changes to bail, the only change is the holidays. So I'm not sure what else you're referring to, Assemblymember Roth.
So, excuse me, are you able to provide that data that was requested?
Thank you for the question, Chair Miller. It's my understanding that the data requested was a general request for data for the entire bill. I'm able to provide data to you today, but
Okay, as quickly as possible, please.
yes, I will get it to you right after this hearing. We can get it to you within 10 minutes. I had a lengthy PowerPoint presentation with data.
Okay.
I knew we didn't have time for that.
Thank you so much. Senator Scheibel, are you part of the presentation?
Thank you, Chair Miller. Melanie Scheibel here, State Senate District 9. I did offer to help answer questions, and I thought there might be a question on bail, but Ms. Noble covered it.
Okay, thank you. Our next question will be from Assemblymember LaRue Hatch.
Thank you, Chair. And I, too, am trying to digest this bill that we just got, I think, maybe an hour ago. I have a question on Section 60.3. This is on page 59 of the amendment that I'm looking at. It's talking about the interception, listening, recording of a wire, electronic, or oral communication by a peace officer is not unlawful if the peace officer or designated person isn't intercepting the communication for the sole purpose of investigating a sexual offense against a child. So prior to this bill, what is the process if a peace officer wants to engage in that activity?
Assemblymember, thank you for that question. Jason Woodard, Nevada Sheriffs and Chiefs. The current process for what is also referred to in the investigative world as pretextual phone calls is phone calls are placed and typically placed by either child victims or their family members. They are placed to the offender and a discussion is then had, or they are confronted, the offender is confronted by the victim or family member in reference to the allegations of the essentially the sexual assault. In current practices, Nevada is one of the only states where detectives, what they will do is witness the call. The call is typically on speakerphone or the volume is turned up in a very quiet location. And those officers then take notes on what they hear during the call and are later called into court if the case goes to trial, and they testify about what they overheard with regard to the conversation. This provision would allow them to execute the calls the exact same way. Therefore, it is not an intercept. They are not attaching any type of device. They are not listening unbeknownst to the party who is making the call. They are simply recording the conversation as the conversation is taking place, and they are there with the victim or the victim's family member witnessing the call.
Thank you. So I'm just wondering, why is it that they have to take notes currently? Why can't they just record it currently? What if they wanted to record it, what would they need to do?
Assemblymember Jason Woodard for the record. To best answer your question, because of the way the law currently reads and because Nevada does not have this exemption like 40 other states, actually 41 including California, it requires that they take notes. And as you can see, there are problems, inherent problems with that, because now as the investigator's taking notes, listening to those calls, their interpretation is subject to their own biases, the way they may have heard something or thought they heard something, rather than an actual documented recording of the call.
Very quick.
Thank you, Chair. I was just trying to get at whether or not a warrant is required for these activities, and really, what is the interplay of this change with the Fourth Amendment and the protections that we have there?
Assemblymember Jason Woodard, thank you for the question. Currently, in these practices, there is no warrant that is required because it does not trigger the Fourth Amendment. This is a phone call that is made by the victim or the victim's family member. It is made to the suspect, and the officers are there merely to witness the call. These practices, these type of investigative tools have been challenged numerous times in the courts. Fourth Amendment issues are not triggered. There have been some questions about Fifth Amendment, and it's withstood those practices as well. So this is a common adopted practice that has been determined to be legal in the courts across the nation.
Jennifer Noble, for the record, Assemblymember, I just want to add quickly that one way to look at this is that right now we are depending on an officer's recollection and notes in terms of characterizing any admissions made by the defendant during those calls. So people are human beings, right? And they make mistakes. They could leave something out, et cetera, that might prove helpful to the defense case. So juries would be able to hear what the defendant said in their own words.
Okay, thank you. Our next question is from Assemblymember Gray.
Good afternoon. Thank you guys for a great presentation and bringing this bill forward. I doubt seriously that it was your guys' fault that we got it at the 11th hour, but thank you for making the changes and doing the things you needed to do. The other thing is we know very well that when parameters for crimes are changed, the reporting tends to change as well, the way it's looked at. So I doubt that's your fault as well. But what I wanted to know is what stakeholders did you guys work with on this bill to come up with this great bill?
Jennifer Noble for the record. The original bill, or the concepts in the bill, were the result of the governor's office reaching out to law enforcement, district attorneys, victim advocates, and experts in the area of opioid addiction, et cetera, and putting together the original bill. I know because I've been in the meetings, there's also been several meetings with the public defenders and the ACLU and the governor's office prior to this hearing. And there actually are some changes in the bill, including the smash and grab provision that I believe was originally proposed by the public defenders in lieu of reduction of the felony theft threshold to $750.
Thank you so much.
Melanie Scheibel, for the record, if I could just chime in here. The smash and grab suggestion actually did not come from the public defenders. It came from me. And it was an effort to find a middle ground between addressing retail theft and not reducing our felony theft thresholds. Like Ms. Noble, like the governor's team, I've been having meetings about this bill since the start of session. As the chair of the committee that introduced the bill, I'm in an interesting position, not being exactly the sponsor, not being the person who brought it forward, but I have been having conversations with people who regularly appear in front of me to talk about the provisions of the bill. And so I have been meeting with the public defenders and the ACLU since the beginning of the session. Getting everybody in the same room together, I think, should be an ongoing process throughout the interim to continue to work towards the best public safety policies that we can achieve. But I can say with confidence that this bill reflects a compromise that my committee and my House was comfortable in passing, because it is a more measured approach than the bill as originally introduced and still has important provisions that will enhance public safety for Nevadans.
Thank you again for this great piece of legislation.
Thank you. Our next question is from Assemblywoman Moore.
Thank you, Chair. Thank you for the presentation. I do have a question regarding sections 29.5 and section 65.5, which references the creation of a strip corridor court. Didn't we already have this and the judges decided to get rid of it?
Jennifer Noble for the record. Because I did not work directly on that provision and just sort of was able to read through it recently, I do know we have folks here who might be able to better answer your question, so I might ask them to come up.
Good afternoon, Madam Chair and members of the committee. My name is Matt Griffin, M-A-T-T-G-R-I-F-F-I-N. I'm here today on behalf of the Nevada Resort Association. And Assemblyman Moore, to address your question, yes, currently in the city of Las Vegas, there are 2 delineated corridors, and there is also a court to address those in the city of Las Vegas. You are correct about Clark County. There was a corridor court, and if my memory serves me correctly, it was about a year, a little over a year in existence, and was decided to not be formed anymore by the Justice of the Peace last year, end of last year.
If I could provide some additional context, Melanie Scheibel, for the record. I practice in Clark County. I practiced in the corridor court when it was there as a defense attorney, and the corridor court was in operation for about, I want to say 14 months, and has since been disbanded. At the time that the corridor court was implemented in Clark County, there were no guidelines, there was no structure in the statute, in the Nevada revised statutes, to establish the court or indicate how it was supposed to be utilized. And I think that proved challenging for attorneys and judges in the corridor court to properly assign cases to the court and to have guidance and direction on why they were assigned there and what to do with them. And so that's why I worked with the Nevada Resorts Association on this language to respond to requests for the corridor court to be reestablished, but to put these guidelines into place so that hopefully it will be more successful this time.
I understand that today's sine die and we're trying to get through this hearing, but were the stakeholders included in this conversation when it was decided that we needed to bring this back?
Melanie Scheibel, for the record, I think that you'll see in section 29.7 of the bill that it includes significant reporting requirements because we were not able to have the robust stakeholder conversations that we wanted to have about the reestablishment of the corridor courts. And it was a choice by my committee to adopt this language anyway in order to avoid the same problem we encountered in the past with the court being established regardless of the fact that there were no guidelines in statute.
So my follow-up question to that, because I know this was all happening recently, why did the judges decide to disband the corridor court?
Melanie Scheibel, for the record, I don't want to speak for the judges. I don't think that it had the desired outcomes. The hope was that it would serve kind of like a community court and that people assigned to the corridor court would develop, my understanding is that the hope was that they would develop relationships with the staff in that court. And the volume was simply so overwhelming that it didn't function that way.
And Madam Chair, Matt Griffin, for the record, I'd also like to point out that this does not establish the corridor court. There's nothing in here that makes the corridor court formation mandatory. It is entirely permissive. It is entirely at the discretion of the justice courts. So, and we will be bringing an amendment to the existing language, and I will walk through that when it's my turn. But even though it's not mandatory in that language, it's still up to the justices.
Oh, I'll have to look again because I did think that said shall in the section.
Madam Chair, for clarification, Matt Griffin for the record, I think the shall relates to establishing the corridor. The corridor itself or corridors, but the court is permissive.
Okay, thank you. Do we have anyone from the Justice Court here or anyone that could speak on behalf of the county or the courts? Just because I think we're interested in why it was disbanded. Okay. All right, thank you. Does that conclude your questions, Assemblywoman? Yes. Okay, thank you. Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. My question is regarding Section 4249 that prohibits automatic record sealing for those convicted of child abuse, elder abuse, or abuse of vulnerable persons. For better understanding, I want to know that how it is different from the current law.
Jennifer Noble, for the record, thank you for the question, Assemblymember Nadeem. So under current law, those crimes are eligible for assignment to a diversion or to a specialty court in a diversion program. In the diversion program, they engage in a specialty court program, right, and hopefully get the help they need with regard to their underlying issues. Following deferment to specialty court, we see, and we have in our statutes a mechanism where we have dismissal of the charge against them and automatic sealing. And so with regard to these offenses, which regard our most vulnerable populations, we thought it would be important for the person to have to wait a bit, because otherwise an employer or a volunteer group, et cetera, they wouldn't have any way of knowing that there had been these issues with older people or children, and they might have access to those same vulnerable populations shortly following their criminal case. So that was the thought there. They would still be eligible for sealing under our regular sealing statute, but they would have to wait. It would not be immediate, and they'd have to petition for sealing.
Thank you so much. Our next question is from Assemblymember Gonzalez.
Thank you so much. And thank you so much for the presentation. I wanted to go back to the questions about the resort corridor. I guess I just wanted a little more context about what evidence or data is being provided to justify the creation of this as a solution to public safety concerns, and how do we know, well, it sounds like we don't know that this is an effective way to deal with this. And I guess my other question or concern is, what is the specific reason that crimes that are happening on the Strip need to have some type of different outcome? Thank you.
Madam Chair, through you to the Assembly Member, Matt Griffin for the record. We do have data. Because of the time, I have not had a chance to submit it. I will tell you that then this is data that we obtained from the Metro Police Department and assembled and presented from applied analysis. And I will provide this to the committee, Madam Chair, after today's hearing. But with respect to violent crime, during the resort corridor court, monthly violent crime was down 14.5%. For property crime, it was down 11.2%. Trespassing was down 15.6%. I'd also say that since the abolition of the corridor court, the active order out provisions, when crime was decreased, was at 2,560. It is currently at 402. So, and I think that's the first part of your question, Assembly Member. And I will submit this, but I'm sorry, I don't recall your second question.
Thank you so much. I was just asking what is specifically happening in this area that there needs to be a whole specific court that has to handle these crimes.
Well, Matt Griffin again, for the record, Madam Chair, through you to Assembly Member Gonzalez. Okay, thank you. I would say, I'm trying to think exactly, the creation, we're not talking about the creation of the court. We're talking about the, a way to deal with repeat offenders. We have members of the employees at all the properties, whether on the Strip or off. There are instances where people have been trespassed out of casinos for 700 times and then are found laying in walkways with drug paraphernalia on their lap, passed out. We've had executives assaulted multiple times. We've had staff assaulted multiple times. And these assaults come sometimes from first-time offenders, and many times they come from repeat offenders. And it is, in our view, the risk to the public is increased when you have the number of people there that are from tourists to employees in that area. And so there are more people that are at risk of these types of offenses and their safety than there would be in ordinary circumstances. To me, it's akin, I'm not talking about the order out court, I'm talking about order out provisions of a corridor. To me, it's akin if I were to assault someone working at a Macy's, a condition is very likely to be that I can't go to that Macy's. If I am arrested and I'm placed on house arrest, I can't leave my house unless I am doing so under the circumstances. It is simply a matter to address particularly repeat offenders, because we have a massive problem with repeat offenders. There are instances where there's, like I said, 700, and if you ask security personnel, they said that's not even the most that we have, 700 times they've been trespassed. So that's what we're trying to solve. And when the order out court was established, put the court aside, but they were issuing that number of 2,500 and some order outs. Crime diminished during that time because repeat offenders were no longer going back into the corridor. And so that's what we're trying to solve.
Thank you so much, and I appreciate the context. I was unaware of that, and so I appreciate that. I'm curious, though, because your explanation is that or the intent is to target repeat offenders, but in the language here, I didn't see anything about repeat offenders, and so I was just curious, where's the disconnect there if the goal is to really talk about these people that are coming back and back and back?
Yes, Matt Griffin for the record, Assembly Member. That is part of the mock-up or the amendment that we are proposing here. What we are proposing is for a first offense, it is optional. It is a may order out from the Justice of the Peace. For a second offense, it is a mandatory order out for 1 year. And then for a third offense, it's a gross misdemeanor. So we are trying to capture, I think, logically and increasing slightly the penalty that they face if they come back again and again. And I will tell you the order out would just be a condition that any Justice of the Peace it would be along with the other conditions to make sure that for that time period at least, that there is no repeat offense from even an initial offender. But we are asking for an amendment, a friendly amendment, I would say, to kind of step up the enforcement of it based on the number of offenses. And those number of offenses, I should clarify, as I remember, is within a 2-year period. It's not a 7-year period like DUIs or the other things. It's just a 2-year period. So we're not trying to drag this out over a lengthy period of time and hang it over someone's head. We're just trying to get them out for a year so that we can reduce that repeat offense.
Okay, I'm sorry, because this whole time when we were talking about an amendment, I thought we were referring to the amended bill. Is there another amendment coming?
Yes,
And when is it coming?
Madam Chair, Matt Griffin for the record. Before, when we found out that this hearing was going at 3:55, and of course we found out that at 3:35, we submitted this amendment to the committee chair.
To me?
I mean, to the committee staff. I'm sorry, not to you, Madam Chair. We will be dispersing it to everybody as soon as we can. I did not have time to make copies of it.
So, just so we're clear, we had the same amount of notice that you did that this hearing was going to occur at this time.
Yes.
And this bill had been exempted a few weeks ago.
Yes.
And there's an amendment that was sent as we were starting the hearing
Yes.
that no one has anyone,
Yes. What?
we don't have it. Is this it?
Yeah. And I apologize, Madam Chair. I will tell you that we didn't know that our amendment came out of LCB incorrectly until last night at 10 o'clock. So from 10 o'clock till today, we've been working to try to fix it with Chair Scheibel. Yes.
Oh, please. Vice Chair Marzola?
Thank you, Chair. And so I'm just trying to clear up the confusion. So we have an amendment on Nellis. That is not what you're presenting on today, correct? Because I think the confusion is everyone has the one on Nellis. We were just given one that looks like it may be a Nevada Resorts Hotel amendment.
That's correct.
So, okay,
That's
is
correct.
this the amendment that you were speaking of?
That's correct. Madam Chair, through you, Assembly Member, that's correct. I came up to answer questions, and I should have clarified at the front. The legislation that is coming to you from the Senate, we have an amendment to that. And what I was going to speak to today is the effect that amendment would have on the existing language. But like I said, we have the data. I haven't had a chance to submit that, and I will. I know you all have the amendment now, but the second we heard it was scheduled, we just shot it out immediately and then came to the hearing room.
Okay, so besides what's on Nellis and what was just handed to us, there are no other amendments coming, is that correct? Or is there any additional amendments? So I just want to make it clear for the committee members.
Matt, for the record, nothing from the Resort Association.
Jennifer Noble, for the record, nothing from the Office of the Governor.
Will there be any other amendments from any other stakeholders, though?
Jennifer Noble, for the record, none that I am aware of and none that I intend to pursue.
Okay. Okay, so with that, I'm going to go back to just one quick question. Assemblymember Moore, did you have an additional question?
Yeah, thank you for that, Chair. My question, I can't recall the bill number, but we recently voted on a bill that we heard in Judiciary that helped with, that increased the penalties for trespassing in the strip corridor. Why would you, if we helped increase the penalties, why would you need this, the recreation of the Justice Court?
Matt Griffin, for the record, I'm not aware of, I know there was a bill that was passed that increased the look-back period. So instead of looking back for 24 months, you could look back 36 months. But I'm not aware of a bill that increased the penalties relating to trespassing.
That is correct. The bill did not increase the penalties. We just had a recent bill. It didn't increase the penalties, but it moved the look back for trespassing from 2 years back up to 3 years. So was that the one you were referencing, Assemblywoman?
Thank you, Chair. Yes, it's SB 371.
Okay, thank you so much. With that, so that members have a few moments to digest the newest amendments, we are going to take a 5-minute recess. Hello, everyone. We will come back to order. Just so you know, there are a few members that are missing because education just went in for a work session. So a few of our members will be participating in that work session and then will come and join us after that. So with that, we will continue with a few questions, starting again with Vice Chair Marzola.
Thank you, Chair. And if I could have 2 for 1 question, if that's okay?
Absolutely,
Thank
Vice
you.
Chair. You're the
So, first I have a request. If we can go through the amendment line by line so that, even though we read it, so that you guys can be on the record what is meant by this amendment and how this amendment came about, and so that we can ask questions. So that is my statement. I also want to know what stakeholders were involved in working on this amendment.
Jennifer Noble for the record. So you want to go through the amendment line by line for the 84 pages? I just want to make sure.
No, I'm sorry.
Okay.
No. Please, no. The amendment that was just given to us 10 minutes ago.
Thank you for the question, Vice Chair Marzola. I see that we have Matt Griffin up here at the table. I do not know the answer to your question, but I believe he may.
I'm sorry, remember I did not hear the question, I'm sorry.
No problem at all. I'll ask it again. So my 2 questions is, can you tell me all the stakeholders that were involved in working on this amendment? So that's one. And my second question is, when was this amendment initially proposed? How long have you guys had it? How long have you guys been working on it?
Matt Griffin for the record. We've worked, well, let me start with your second question first. We had submitted this amendment to the bill in the Senate. I'm not the best at time, but it was weeks ago, probably, I'm going to say 2 to 3 weeks ago. We did not have confirmation whether or not it would be adopted until recently. As far as the stakeholders we've worked with, most of this has come from data and information supplied by Metro, the DA's office in Clark County, the councils that were involved in the order out court. It is the security officers within. And then we did have conversations with staff members, because there is the piece in here that I'll go over when it's my turn. I'm sorry for the confusion, but I'll go over when it's my turn, related to the protection of workers. So there was a discussion with the Colonial Union about that. And we also discussed with the security officers executives and employees at the casinos to see about their encounters with criminal activity or feeling unsafe or feeling threatened or all that stuff. So if I may have left out 1 or 2, but I think that's almost all of them.
No, thank you for your answer. And Chair, if I could request that he go through the amendment right now. Thank you.
Okay. Thank you, Madam Chair. Matt Griffin for the record again. I'll start, I think, if it's all right, Madam Chair, since we've kind of glossed through introductions, and I'll just go straight to the language. And please understand, when I'm speaking about this, I'm talking about what the effect of our amendment from the Nevada Resort Association would have in the bill that came to you from the Senate. So I will point out the sections that I'm talking about, but I'm going to be talking about what we are going to be asking for this to be amended to. So starting first with section 65.5, we would seek to add a section in that would reaffirm a large county's authority, such as Clark County, to regulate criminal misdemeanors in their jurisdiction by adopting local ordinance. With respect to the existing language that's in section 65.5, it would provide that counties with 700,000 residents or more, the counties must establish an order out corridor, which do not have to be contiguous, and there can be more than one order out corridor, which is currently what's going on in the city of Las Vegas. There are 2 order out corridors in Las Vegas. The corridors shall include areas where there is a heightened risk to public safety and the state's economic stability due to the concentration of tourists and employees in the area. This section 65.5, and this goes back to what we discussed earlier, it also provides that a justice court may, permissive may, establish a program specifically to handle crimes committed in the order out corridors. This subsection is permissive insofar as it does not require the creation of a judicial program, but provides the explicit authority to do so in connection with the mandated order out provisions of Section 65.5. Next, moving on to Section 65.5, subsection 2. This provides certain penalties for crimes committed in an order out corridor. For a person who commits a crime within the order out corridor, for a first offense, that person may, permissive may, be ordered out of the corridor for a period of up to 1 year. So that is entirely a judicial discretion decision for a first offender. There is an amendment. I apologize, talking with folks in the hallway between the hearings. I do have a change in what we've submitted. For a second, I'll explain, Madam Chair. Yes.
Did you say there's another amendment
No,
coming?
there's not. There's not. I want a clarification, I should say. It's a
Okay,
clarification.
we love clarifications.
For a second offense or any subsequent offense, second, third, fourth, or fifth, it is a must for a period of 1 year. There is no gross misdemeanor or any of that. That was a misprint. It is just a must order out for a period of 1 year for a second, fifth, 20th, whatever offense. The remainder of that section allows that a justice court may by local ordinance provide for exemptions under which a criminal defendant may physically enter the corridor or corridors for a specified purpose or for specific purposes during the applicable order out period. What that means is if you have been sentenced to an order out and your physician is in there, your religious services are in there, you have to take transportation to and from work through there. Those types of activities will all be exempted. You will be allowed to enter the order out corridor if you have those reasons, and it's going to be up to the justice to make sure that those accommodations are taken care of. Moving now to section 1.3 and 1.7. Similar to the statutory treatment of school employees, transit workers, and utility workers, the proposed provisions of Section 3 make, under certain circumstances, a criminal offense against hospitality staff that occur within the order out corridor, subject to heightened criminal penalties. Those heightened penalties would be for a battery causing substantial bodily harm. It would now be a Category B felony rather than a Category C. And for a simple battery, it would be a gross misdemeanor instead of a misdemeanor. So this is just affording the hospitality staff that work every day in these resort hotels the protections that these other classifications have to deter people from committing crimes or threatening or obstructing them from doing their jobs in the corridor. The last part of my presentation, Madam Chair, for the changes that we're proposing, and it's in section 29.7. And this relates to the data. We have one change in that amendment before you, which is that this data must be collected in a county where they have established a corridor. Under the current language right now, it says the data must be provided if they establish a court program. We're saying no, not continuing a court program. We're saying if you have a corridor, and the purpose of this is we want to analyze whether we're effective at accomplishing what we're trying to accomplish. And if we're not, then we're going to be back here and changing what we're talking about. If we are, then we're going to go about business as usual. And so there's two reporting requirements in this amendment before you. Number one is that which is to be provided to you all in the legislature annually. That includes the number of defendants charged and convicted, the rate of completion of sentence, repeat offender data, and diversion program data. Because if you complete a diversion program, you can be released from any order out provision that has been imposed upon you. So that data will be submitted annually to the legislature. That data will also be submitted to the county commission monthly, along with the following data as well. And that is the aggregate number of cases, the name of the presiding justice court judge, the case number and identifier, not the name of the defendant, anonymous. We're not looking to provide names. We're just looking strictly for, is this program actually doing what we're thinking it does? And as I said before, we do have data that when they were being issued, it was effective, but we want to make sure that it is continuing effective, because we're not here to actually pass criminal laws. Our goal is strictly to solve a problem. And then the last piece of information that is required to be submitted to the county commission monthly is repeat offender data. And that would include things like time in between offenses, incarceration data, things like that. So that is the conclusion of what we are proposing in this amendment. And I'm happy to continue answering any questions, because I know this is a, it's sine die night, so it's how it is.
Right. Vice Chair, do you have any additional questions?
Not right now, thank you, Chair.
Okay, thank you. Then we will move on to Assemblymember Roth.
Thank you, Chair, for the second bite at the apple. I just had a few questions going through the first amendment that we received today, not the subsequent amendment. And a lot of it seemed pretty familiar to me, specifically looking at Section 60, the warrantless wiretaps. I know Section 52, the excluding holidays, is something that was brought up last session and did not move forward. And I know Section 60, I think that was AB 275, which didn't make it through this House. And so can you just kind of walk through what stakeholders were engaged in resurrecting these and then bringing them back to this body when they failed in the first House?
Jennifer Noble, for the record, thank you for the question, Assemblymember Roth. I want to first turn to the portion of your question regarding the holiday exclusion. Last session, prior sessions, the stakeholders who have concerns about this requirement have included our courts, justices of the peace, public defenders in the rural counties who have trouble covering these hearings because they're not necessarily full-time public defenders, prosecutors, court staff, et cetera. And I think while, yes, this provision was raised and it was not passed last session, I think for many sessions, and appropriately so, this legislature has laudably dedicated its efforts to improving rehabilitation for offenders, to making sure that people are not held on bail that they cannot afford in order to get out of custody, that there's a presumption against bail, lots of criminal justice reform. But I think it's equally important for this body to turn its gaze to victims and what it's like to be a victim of a crime and have to go in on Christmas Eve to exercise your constitutional rights. And so I think that this strikes a balance between protecting the right to a hearing within a reasonable amount of time, which is what Valdez-Jimenez requires. It doesn't specifically require 48 hours. And taking a look at what we put victims through in terms of when they have to exercise their right to testify at any hearing regarding release. For the provision you referred to as a wiretap, I'm going to ask Lieutenant Woodard to answer that because that's not my understanding of how that provision works.
Thank you, Assemblymember Jason Woodard, Nevada Sheriffs and Chiefs. This has been a longstanding conversation that's gone on in the investigative and law enforcement circles, and has been an issue in discussion with not only law enforcement, but prosecutors as well. And it's also been discussed as part of essentially a national standard, or a standard that's exercised by investigators and has withstood, as I said before, tests within the court world for the use of these practices. Nevada just happens to be one of the states that doesn't allow it.
Is it a brief clarification? Okay, briefly, please.
Just to clarify my question, I understand we already went through a whole policy hearing on it in the first House. So my question is, what stakeholders were engaged following that bill dying that resulted in it now being put into this bill?
Assemblymember, I'm going to do my best to answer your question, but I think the same stakeholders who were initially involved in bringing it forward were also involved in bringing it forward again, or for it becoming part of this particular bill. In addition to that, it was ultimately added to the discussion was had with the governor's office, and it was ultimately added to this bill.
Melanie Scheibel for the record. If I could add something?
Briefly, please.
Sure, about the stakeholders involved. Lieutenant Woodard also met with myself and some other members of my committee as well as my caucus, and I think that we did go back and watch the policy hearing in this committee, and clearly my house has passed this policy because we just have a different perspective on it. I also practice as a criminal defense attorney, and my perspective is that I would always rather have a recording of my client's conversation than an officer's paraphrasing of my client's words. And so I view this as a protective measure for defendants who are being accused of sexual assault against a child. This does not allow the interception of a conversation for which the peace officer is not present. This simply exempts them from the two-party recording statute that is otherwise applicable even in an investigatory context. And so I'm comfortable with this language because I have worked these types of cases and relied on the testimony of both victims, perpetrators, as well as law enforcement, and I think this provides those protections.
It actually is a valuable hearing for everyone to go back and watch. Assemblymember Hansen.
Thank you, Chair. Thank you for being here. Thank you for the work. A lot of work, it looks like. First of all, I know there's been a lot of frustration by all of us that this appears to be at the last minute and a lot of work. And that is true. But it also, when you look at the history of the bill was introduced April 7th in the Senate, referred to Judiciary, and then we're here. So I think a lot of us here, we have no control of when things get scheduled, and so I think it's important to realize that we're here to talk about this bill, ask our questions. The timeline, that was not up to any of us. In regards to AB 236 in 2019, which I was here for, some of the things that we're talking about, as mentioned earlier, were not in that bill. And of interest to me in particular, and I don't think we've spent enough time on this, could you expound just a little bit on the child pornography sections and then the stalking sections? I think it was section 2 on the stalking, maybe section 60 on the child pornography, to help us understand that better.
Jennifer Noble for the record. Thank you for the question, Assemblymember Hansen. So we have a case in Nevada, and I think I referenced it while I was trying to read this amendment as fast as an auctioneer so that we could get through this hearing and be conscious of your time. So in Castaneda versus State, that's a Nevada case that talks about how in Nevada, and I think in that case the defendant had 15 images of child pornography, he could only be held accountable for one charge of possession of child pornography because they only had him in possession on one date with the forensic data. But in dicta, the court commented that it's a laudable goal, we value as Nevadans or, as a society, there's a good social value in recognizing the harm to each individual child. And they talked about actually the prospect of per image prosecution, unit of prosecution. At least 17 states have unit of prosecution that's per image. In discussions with, and I'm not saying they agree to this, but it's my understanding that in discussions with stakeholders, including the public defenders, a per child unit of prosecution seemed to be more fair because it's one charge for each one of the children that that is depicted in these images, who continues to be harmed by the sharing of the images. I think that this is definitely different from anything that AB 236 touched upon, and I think it would be important for Nevada to look at adopting this. I think the other, you talked about stalking, was that your other question? So with this, again, not an area that would repeal AB 236 in any way or seek to do so, and even in some sort of roundabout fashion. We're simply updating our stalking laws so that they fit what's going on now, so that victims can better have an idea that certain behaviors are considered stalking, so that prosecutors have statutes that are more clear in terms of what types of activities fit the course of conduct in a stalking case. But again, that was definitely not part of AB 236. That was focused on a different aspect of the criminal justice system and criminal justice reform. And so it's certainly not trying to undo any of the policies therein.
Thank you, and I have a brief follow-up about the stalking as well. I see it referenced in the digest, and I'm trying to get to the actual language where it is in the bill, but the word that I'm interested in is, so when it says expands the unlawful, and I'm reading from the digest because I'm trying to flip through these pages. Section 2 of the bill expands the unlawful act which constitutes stalking to include certain courses of conduct that would cause the victim to feel terrorized, frightened, intimidated, and so on. And so that's, I guess my question, as I'm trying to get to where it is in the bill, is because it doesn't necessarily here, does in the bill, could you tell me where it is in the bill? If it actually addresses or explains what those, what that conduct or that actions would be? Because if not, I'm just wondering about feelings or not, what would be the burden of proof for feelings and so on. Are you following my question?
Yes, Chair, I believe I am. So I'm going to direct you to Amendment 986, which is, right, okay.
Yeah.
I just want to make sure, I'm sorry, Jennifer Noble for the record. Thank you, Chair Scheibel. Page 15, toward the end, is where we start that language that talks about a victim feeling terrorized, frightened, intimidated, harassed, or fearful. And that is at lines, I believe, around 47 to 49. That is our current law, so that's actually not a change that 457 is making here. The change in that section actually is just including as a person who could be a potential target of a stalker, a person with whom the victim has or has had a dating relationship, but they don't necessarily cohabitate with. So right now, if it's your boyfriend or your girlfriend or whatever, and your stalker is also targeting them, in order for that to count in terms of the course of conduct, you have to actually cohabitate. And in the other, in the Senate, we were able to present some examples of, non-cohabitating boyfriends, girlfriends, et cetera, that were targets of a stalker.
Thank you so much. And again, it's green in the digest, so I was assuming it was green everywhere, but thank you for that. I think we have one more question from Assemblymember Gonzalez.
Thank you so much, Chair, and thank you so much for being here in this amendment. I wanted to go back to this amendment that was provided by the Resort Association. I was curious, what are your top 5 repeat offenses on the Las Vegas Strip?
Madam Chair, your indulgence for 1 minute, 1 second, sorry. Assemblymember Gonzalez Macri for record. I don't have the top 5. What we did in the data that we collected is we did trends and we looked at violent crime versus trespass versus property crimes, things like that. Well, I don't have any information on what our top 5 crimes are for the Strip. I'm not sure if I could even get that information, but I can sure try.
Thank you. I guess I'm still having some concerns about this amendment.
Are you asking for a
and-
follow-up,
Oh,
Assemblywoman?
yes, a follow-up, please.
Quickly, please.
I just have some concerns about this amendment and this corridor criminalization on the Strip. And so, it's tiny tie, so we could talk more offline. But this amendment talks about all crimes. And so I guess my intent or question is, if we are just targeting these repeat offenses, why those specific offenses were not discussed?
Matt Griffin for the record. Honestly, because I don't think that we know the top 5. I think we are dealing with data that we collect from Metro and from interviewing, whether it's members of the culinary union, whether it's executives that are afraid to get to the parking garage or whatever the case is, or if you have security officers. There has been some horrific cases of what is happening on the Strip. Noses fractured, faces fractured, security guards threatened to be killed, all of that. So we're trying to get the folks that are in Las Vegas on the Strip for the wrong reasons to not come for a year. And I don't know that I can say that whether the number 1 versus number 3 versus number 5 crime, what it is and how to best address each of those. We just know from when those mandatory order outs were in effect, we saw a decrease across property crime, things like trespassing and violent crime. So I apologize. I'm going to try, and I'm hoping someone behind me in the room might be able to point me in the right direction for that, but I don't have it right now.
Oh, thank you so much. With that, that actually concludes our questions. So, as I had mentioned at the opening of the hearing, we were going to allow the opposition to come and present for 10 minutes. So I will welcome up the opposition, please.
Good evening, Chair and members of the committee. John Puro from the Clark County Public Defender's Office. I want to talk a little bit about process and then 2 portions of the bill, since there's a few of us and we have a short amount of time. In 2019, I was here on AB 236. We sat in that woodshed and we worked together multiple times. That was not the process here. Paloma and Angela have been in the building all session long, every day the building was open. They had asked Ms. Noble, was she working on the bill? She said, it's not my bill. And then when we finally met with the governor's office the day before the bill hearing, they called Ms. Noble and said, actually, she's the one that wrote this bill. And now today at the dais, she says she's not taking any more amendments. Like, we were cut out of this process for a long period of time. The process has been bad. This bill was brought with no data, no evidence backed, nothing like AB 236 happened. Now I want to focus my opposition on 2 sections of the bill. Section 57, dealing with witness immunity. This body rejected this exact same proposal in 2019 in AB 55 because that provision is not victim-centered, it's conviction-centered. It's basically the prosecution saying, I want to get you to testify to help us out in this case, and then we're going to prosecute you for the other things. Nevada has robust immunity throughout. This section could really hurt a domestic violence victim who flips on her abuser, and then the prosecution wants to prosecute her for ancillary crimes. I would ask you not to adopt Section 57. Our proposed amendment removes that section. The next section I want to deal with is Section 53, a prompt bail hearing. If you look up the word prompt in the dictionary, it says without delay. And again, in 2021, this body moved that prompt meant 48 hours. The Constitution doesn't take holidays off. The presumption of innocence doesn't take holidays off. And actually, 48 hours is helpful for victims because they know within that arrest, within 48 hours, that person will get a hearing. And it's tough for me to stomach that when then later in another section within the bill, they ask for city attorneys to do bail hearings as well as district attorneys and then get holiday pay. Last session, we paid the judges to do holidays as well, and that appropriation still stands. I would ask you to reject those 2 sections, and I'll kick it over to my colleagues.
Good evening, Chair Miller and Vice Chair Marzola and members of the Assembly Judiciary Committee. Paloma Guerrero, Paloma Guerrero, on behalf of the Clark County Public Defender's Office. I'm going to talk about 2 specific issues with the bill. The first starts with Section 60.1 on page 58. And as some of you have ferreted out, this language should look very familiar. It's AB 275, a bill that this committee killed. It was properly vetted, had a full and fair hearing, and this committee chose not to advance the measure. And now they're asking you again to erode the Fourth Amendment. And in that first hearing that was presented, Peg Sample could admit the question that Assemblymember LaRue Hatch asked, which is what the process is now and what that requires. And the process for law enforcement to record a phone call, even with one party consent, is that they are required to get a warrant. It's something that Peg Sample admitted, and that they needed this change because warrants were too onerous. But judges exist for a reason. They are an important check and balance in order to make sure law enforcement is not conducting surveillance without accountability. Everyone has a right to privacy. No one should have to worry about someone secretly listening in to their phone calls. Law enforcement can already do this, can do what they're trying to do, but they just need that warrant, and that matters. Judges serve as constitutional gatekeepers, ensuring there's real justification before someone's privacy is invaded. We don't let police search homes without a warrant just because a crime is serious. The same standard must apply to phone calls. We all want these types of crimes to be prosecuted, but we should not tear down the Fourth Amendment when law enforcement can easily get a warrant. And as a criminal defense attorney, I would rather law enforcement follow the law and get a warrant and not infringe on my client's constitutional rights. Judges are on call. It's not onerous to get a warrant. They have warrant phones, and they can even answer one at 2 in the morning. The second major concern with the bill lies in sections 4, 30, and 51, which introduce procedures for new gun surrender compliance hearings. These sections require a hearing to determine whether a person who has been ordered to surrender their firearm due to being legally prohibited from possessing them has actually done so. And on the surface, this does sound reasonable, but there's a significant constitutional issue in sections 4C of those provisions. This subsection allows a court to cancel compliance hearings if one of 3 things happen: if the person signs an affidavit, if they provide a receipt or documentation, or if the court issues a search warrant. And this last option is deeply problematic. Search warrants require probable cause, which must be based on specific articulable facts that suggest a crime has occurred, and courts cannot issue a warrant simply to verify compliance with an order. Probable cause cannot rest on suspicion alone, let alone a desire to just make sure.
I would just like you to know we're at 5 minutes.
We'll hand it over.
Good afternoon, Chair Miller, members of the committee. My name is Angela Knott, ANGELA-KNOTT, on behalf of the Washoe County Public Defender's Office and the Alternate Public Defender's Office. My opposition is regarding Section 2, the stalking, and Sections 44, 46, and 49 as they relate to treatment court. First, with regards to Section 2 stalking, our only opposition is to the definition of act, and that is found on page 17, lines 15 through 16. We heard earlier from Ms. Noble that she says one of the purposes of this section is to make it clear in what type of activities and conduct in a what are the activities and conduct in a stalking case that would be illegal. We find that when we read act, which includes without limitation assessing a social media account of a specified person, is too vague, and without clear limitations or context, this vague definition could lead to inconsistent enforcement, prosecutorial overreach, and unintended criminalization of conduct that falls outside the scope of this law. This ambiguity not only undermines due process, but I have concerns on how this will affect our younger people, our younger generations, especially those teenagers who are now using their social media for everything. So when it comes just to Section 2, all we're asking for is to remove subsection 11A. With regards to the treatment courts in sections 44, which is on sections 44, 46, and 49, all we're talking about right now is removing the automatic sealing of those records when they complete their treatment. Why we believe that that section should be, or that subsection should be eliminated, our proposal is to simplify it and add, say, you can't have automatic sealing, but you must have a hearing. There is another statute, NRS 179.255, that if you're trying to seal like an arrest warrant that didn't go anywhere or your charges were dismissed at a preliminary hearing, you can file a petition with the court to have that record sealed. But these are people like veterans who have completed veterans court. And this treatment court is not easy. And so now what we're doing is expecting these people who've just spent a year of treatment, and now we want them to jump through extra hoops just to have their record sealed. Let's have the hearing.
Chair, I can actually speak I don't know how much time we have left. Oh, that's perfect for me. For the record, Attar Hasibullah, first name spelled A-T-H-A-R, last name H-A-S-E-E-B-U-L-L-A-H. I'm the executive director for the ACLU of Nevada. In conjunction with everything my colleagues are saying, I want to raise a couple other flags. If the Resorts Association submitted this amendment 3 weeks ago, the fact that we first found out about this last night on a corridor part, and today at 2 o'clock with respect to an order out provision, something we have been working on actively to litigate for 2 years, that is unacceptable. It is a joke that this body, this committee, is forced to hear this at 5 p.m. on sine die. It is totally unprofessional beyond measure. I don't know if that lies at the governor's steps or at Chair Scheibel's steps, but we didn't know any of this until today. We met for the first time last Thursday to try to work out and negotiate and actually deal with the issues that were mentioned. Did that happen? No. In fact, what was brought back is things that this committee has killed, already voted no. And now you have to consider this again. You're being asked now to sell out your constituents' liberty and constitutional rights at the behest of interests by the resorts. A court that has already ended specifically, and one that doesn't need to exist. But we're now here being told this is the bill that needs to pass because, what, Democrats need to seem tough on crime? This is not tough on crime. This is stupid. It's reckless. It would sell out your community members. It's totally unacceptable. You should not have been put in this position, and it's an embarrassment. Even if this went to a special session, at least you could consider this and do some. There's no ability to even process this within the 4 hours that were left. And I'm not blaming anybody necessarily behind me for that, but this is a disaster. It's a total shame, and it's a disgrace to policymaking, period. We could line this up for 2 hours. This should have been a 2-week hearing. But for 3 weeks to have a notice and nobody knows about it until today, and now you're asked to sell out your constituents, it's totally unacceptable. This should not move forward. These 2 sections should be totally stripped from the bill. They weren't even discussed. Not even discussed. Not even a record of us having one conversation. These 2 gentlemen behind me, we spoke last week. I don't even know if they knew about it. They're the governor's staff. I don't even know if they knew about it. This is a last-minute addition. Surprise, everyone. Surprise. Thank you.
Thank you so much. With that, we will go ahead and open it up for testimony. So as I stated before, we will do 30 minutes of support, 30 minutes of neutral, 30 minutes of opposition. Again, please keep your comments to 2 minutes each. Ditto, and I agree, and I second that, is much appreciated, especially today as we are on sine die. So make sure that you also please state your name and spell it for the record. And with that, we will go ahead and begin support testimony for the Senate bill here in Carson City.
Good afternoon, Chair, members of the committee. My name is Greg Ferraro, appearing today on behalf of the Nevada Resort Association, and wanted to just offer our strong support for the amendment that our organization has placed before you. Very late, yes, indeed. But we've been working with the governor's office and with the Senate Judiciary Committee, and now with you in that order. It's an urgent matter on behalf of Nevada's hotel casinos on Las Vegas Strip and surrounding areas, and on behalf of our employees and teammates. We think that this is critically important, and we urge your strong consideration.
Good evening, Chair Miller, members of the committee. For the record, my name is Nick Schneider, Director of Government Affairs for the Vegas Chamber, here in support of SB 457, specifically regarding the resort safety corridor contemplated in Section 65.5. Thank you so much.
Thank you, Chair, members of the committee. My name is John Jones, here on behalf of both Clark County District Attorney Steve Wolfson and the Clark County District Attorney's Office. We are in support of SB 457 and want to thank Governor Lombardo, his staff, and Chair Scheibel for their work on this bill. We are in strong support. Thank you.
Good afternoon, Chair and members of the committee. My name is Joshua Martinez. I'm a captain with the Las Vegas Metropolitan Police Department. I just want to voice our support for SB 457, and we want to touch on that we believe that the court worked when it was in process, and we would like to see that added back in. As you heard from previous speakers, The court was in session from January of 2023, and then it sunsetted in November of 2024. And in that time period, the stats that were given in 2024, we saw a decrease in criminal activity in the resort corridor from 2023 to 2024. And we would like your support on this piece of legislation. Thank you.
Good afternoon, Chair Miller, members of the committee. Jason Walker, Jasonwalker, representing the Washoe County Sheriff's Office, supporting Senate Bill 457 for all the points outlined in the presentation.
Good afternoon, Madam Chair, members of the committee. For the record, my name is William Horn with Western Public Affairs, representing Safe Nest. Safe Nest is a nonprofit dedicated to ending domestic and sexual violence. I know the time is short, Madam Chair. Let me just leave the committee with some statistics. Every month, and this is in support of Section 4, if they're the same places in the amended bill, 4, 30, and 51. Every month, more than 70 women are shot and killed by an intimate partner. Nearly 6 million women have reported having a gun used against them by a current or former partner. Despite accounting for just 0.34% of the U.S. population, Nevada accounts for 3% of these homicides, with an average of 2 women killed each month. According to Geller et al. 2021, 68.2% of mass shootings in the U.S. originate in domestic violence. 80% of mass shooters have a documented history of strangulation, a critical indicator of escalating lethality. In 2024, Nevada ranked as the second most dangerous state for domestic homicides. Clark County was the most dangerous county in the country, and firearms were the #1 weapon used in those murders. When there's a gun present in an abusive partner situation, those abused partners those survivors are 500% more likely to be murdered than someone in a similar situation. In June 2024, this became heartbreakingly clear when a man in North Las Vegas with a documented history of domestic violence used a firearm to kill 5 people, including his former partner, her relatives, and a child before taking his own life. If we're serious about ending domestic violence homicides, we must start by removing the deadliest tool in an abuser's hands. I urge your support for this legislation. Thank you, Madam Chair.
Good evening, Madam Chair, members of the committee. For the record, Erin Midby on behalf of Boyd Gaming. We just wanted to express our strong support for the bill, especially with the amendment that was added by the Nevada Resort Association earlier. We believe that this enhances effective tools that have proven to reduce crime in our properties and in our resort corridors, both on and off the Strip, especially as it relates to habitual and repeat offenders. Thank you very much.
Thank you, Chair. Members of the committee, for the record, Mike Cathcart, C-A-T-H-C-A-R-T, representing the City of Henderson. I want to thank the Governor's Office for sponsoring this legislation, and I want to thank the committee for the opportunity for the hearing today. Public safety is a core component of municipal services and is something our community highly values, as demonstrated by our most recent survey, which showed crime prevention being the highest priority of our residents. The city is supportive of the changes contained in this bill, including the stricter penalties for taking a life while driving under the influence of alcohol or controlled substances, the more comprehensive approach to establishing medication-assisted treatment programs that includes additional education for first responders and increased partnership with the Department of Health and Human Services, and also the provisions reforming pretrial release timelines to exclude holidays. For these reasons, the City of Henderson is in support of Senate Bill 457 as amended, and we urge your passage of this important criminal justice reform legislation. Thank you.
Good evening, Madam Chair. Brian Wachter, W-A-C-H-T-E-R, Senior Vice President of the Retail Association of Nevada. We very much appreciate and support the amended version that came over from the Senate. We believe that this is an additional tool now in the toolbox for Nevada to be able to handle organized retail crime. It's an employee safety issue, it's a customer safety issue, and we appreciate the opportunity to be able to have the hearing. Thank you, ma'am.
Good afternoon, Madam Chair and committee members. My name is Jason Gray. I'm Vice President, Government Affairs for MGM Resorts. I'm here to testify in support of the Governor's SB 457 as amended and as proposed to be amended in the mock-up. Just a little bit of history. Our company's been very involved in conversations with the Justice Court, with Metro, with the DA's office, with interested stakeholders, of course, of the last 2 years. The Board of County Commissioners adopted an ordinance in August of 2022 to establish an order-out corridor. The main basic function of that is if you commit a certain type of crime within that corridor, a Justice Court judge has discretion to issue an order out as a condition of a suspended sentence or deferred adjudication. It's not a punitive policy. It is intended to emphasize deterrence by saying, listen, if you agree to stay out of this area, and I think we can all agree, I hope we can all agree why an order out corridor is appropriate for our resort corridor. We welcome 40 million people a year. The resort industry remits 30% of the state's general fund. We personally employ 45,000 hardworking men and women who are your constituents who we deserve to be protected. The Justice Court established a resort corridor court in May of 2023. That lasted for about 1.5 years. We like the questions about data because it's still unclear to us why the court was disbanded. We saw no compelling justification or data put forward as to why the court was disbanded, which is why we think it's really important that the committee support, and we hope that the body will support the data provisions included in our mock-up, because we would like to see data on how order-outs are being processed by the Justice Court so that we can make evidence-based decisions as a community as to whether or not the policy is working. We think the order-out ordinance provisions are essential and critical to maintain. I'd be happy to meet with any of you to talk in greater detail about our company's perspectives on what has and has not been done and what we do and do not know. We support the bill, and we urge your support. Thank you very much.
Good evening, Madam Chair, members of the committee. For the record, I'm Paul Enos, the CEO of the Nevada Trucking Association, here today in favor of the amended version of Senate Bill 457. You know, in terms of the trucking industry, we have a $35 billion a year annual issue in this country with cargo theft. We also are on the roads, so we do also appreciate the increased penalties for DUIs and for driving under the influence. So for these reasons, we support this bill. I want to thank the governor and Senator Scheibel for moving this forward. Thank you.
Thank you, Madam Chair, members of the committee. For the record, Kelly Crompton, representing the City of Las Vegas. Public safety is one of our main priorities of the City of Las Vegas, and so we echo the comments that the City of Henderson put on the record as it relates to DUI and pretrial release. Thank you.
Good afternoon, Madam Chair, members of the committee. For the record, Andrew McCam, the Executive Director of the Nevada Franchise Auto Dealers Association. Echo the comments of the previous speakers. We did speak in favor of this measure over in the other house, predicated on a simple fact that measures that enhance quality of life, in this case, improve public safety, we wholly support, and we encourage the committee's support of the amended bill. Thank you.
Good evening, Madam Chair and members of the committee. For the record, Miranda Hoover with 3C House, representing the Energy and Convenience Association of Nevada, representing over 1,500 convenience stores across the state. And for all of the comments already made, we are in full support of this measure and urge your support. Thank you.
Thank you. Is there anyone else here in Carson City in support? Not seeing anyone, and not seeing anyone in Las Vegas. Broadcasting, please open the lines.
If you would like to testify in support of Senate Bill 457, please press star 9 or raise hand in your Zoom window now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 457, please press star 9 or raise hand in your Zoom window now.
Hello, Devin Livesey, DEVIN LIVZIEY, Vice Chairman of the Clark County Republican Party. This is very key bill in helping keep not only employees and customers safe at retail level, but also keeping our employees and customers safe on the resort corridors, as is amended. We appreciate the fact that it has the DUI in it, so that when we're out driving or any individual is out driving safely and that person is irresponsible and jumps behind the wheel of their car intoxicated, that it makes it more difficult for them to get back on the road. That with the keeping our children safe from the exploitation of the porn children's porn. For these reasons, we support this bill, and we thank the governor for bringing this forward, and thank you for your time.
If you have recently joined and would like to testify in support of Senate Bill 457, please press star 9 now or raise hand in your Zoom window to take your place in the queue. Chair, there are no other callers choosing to testify in support at this time.
Okay, thank you so much. Then I will open it up for opposition testimony beginning here in Carson City.
Thank you, Chair and members of the committee. My name is Harrison Epstein, Harrison Epstein. I'm representing today the National Lawyers Guild of Las Vegas. I'm speaking today to two sections of this bill. First is Section 51, that is page 53, line 21. Now, I understand that this bill is very long, and some people might have missed that this removes the presumption of innocence and likely violates the Second Amendment. If Assemblyman Gray was accused of a crime, a judge can order that he turns in all of his firearms for the duration of the case. Without being convicted of any offense, Assemblymember Gray and other Nevadans can have their right to bear arms infringed.
Could we use a more generalized name, please?
My apologies. Any Assemblymember or any other Nevadan might have their right to bear arms infringed. This provision would take away a person's constitutional rights without a trial. Second is Section 1.3F2. That's on page 10, line 30. This section is already adding resort, arena, stadium, and convention center employees to the protected person categories for assault and battery. Now, this subsection allows for the enhancement, making assault or battery a gross misdemeanor punishable by up to 1 year in jail, even if the employee is just traveling through the corridor. A fight while traveling can be completely unrelated to that person working in the hospitality industry, and yet the enhancement would stay the same. This provision is only furthering an unequal application of justice for reasons that can be entirely unrelated to the incident. We are asking you strongly to remove these provisions. Thank you.
Thank you, Chair and committee members. My name is Nick Shepak, Nickshepak. I am the Nevada State Director of the Fines and Fees Justice Center. The process to getting here today has been void of any community input, and many stakeholders have been left out of the process completely. The target has been constantly moving. It's been amendment after amendment, mock-up amendments that reference different amendments. Today we have another amendment, and the question that I have for you is, while this isn't a finance committee, how much is this going to cost the state? This is a bill that is moving us back towards mass incarceration. It increases hearings. It's going to create new courts. We are going to see massive increases in caseloads for PDs, DAs, judges across the state, and there's absolutely no time, because the bill is continually changing, to figure out how much this is actually going to cost. And DOC has a fiscal note on it. They've had to change it multiple times. We have no idea what this is going to cost a taxpayer, what the impact is going to be. There's no evidence presented on any of the policies inside of this piece of legislation. We got here in a reckless manner. Passing the bill as written is equally as reckless. It's going to be expensive. Nevadans are going to be asked to pay a bill, and we have no idea how much that bill is. Thank you.
Good evening, Chair Miller and committee members. My name is Jessica Munger, Munger, from Silver State Equality, Nevada's statewide LGBTQ+ civil rights organization, and I echo the comments made by my colleagues here. We are opposed. Thank you.
Good evening, Kayla Maese, Kaylah testifying in my personal capacity today. Members of this dais, you have a very important decision to be making in the next 6 hours. When you're making this decision, I urge every single one of you to look up the name Kevin Menon, an officer who was believed to have been orchestrating fake arrests by instigating situations with the public without probable cause. When we are looking at the egregious amendments that are being brought forth by the the Nevada Resorts Association, we really need to be looking at the consequences of what this is going to do. Individuals who are down in our corridors, on the Strip, they are going to be affected. Tourists are going to be affected. We're already concerned about a downfall in tourism. Doing this is going to further hurt our state. So as you are making this decision in the next 6 hours, think of your constituents, think of people of color, think of everyone who is going to be affected by these amendments. Thank you so much.
Good evening, Chair Miller and members of the committee. My name is Denise Heredia, Heredia, and I'm the Associate Director of Return Strong. We're an organization that advocates for the human rights and dignity of people in prisons in Nevada and their families. We hear daily from incarcerated people about deeply concerning conditions, widespread medical neglect, extended lockdowns due to chronic understaffing, inedible food, unsanitary living conditions, and extreme temperatures due to broken AC and heating. These are not isolated cases. These are patterns across NDOC facilities, and you can find excerpts from some of these letters in our exhibits in this bill. NDOC does not have the staff or systems in place to meet even the most basic standards of care and safety, and SB 457 does nothing to fix this. It worsens it by funneling people into an already broken system. This affects hundreds of communities and thousands of Nevadans, yet the rushed nature of these hearings and amendments have denied many the fair and timely chance to testify and be heard. For all these reasons, we urge you to reject SB 457 and instead adopt the coalition's amendment. Thank you.
Good afternoon, Chair. Good afternoon, Chair and members of the committee. My name is Blanca Macias Villa. That is Blanca. Last name Macias-Villa, and I'm the Deputy Director with Make the Road Nevada. I'm here to urge you to vote no on SB 457, not just as a professional, but as someone who walks alongside our families every day and also proudly grew up in East Las Vegas. This bill may look like a safety measure, but to the members of Make the Road, it reads like another policy that will tear more of our families apart. The U.S. puts more folks behind bars than any other country in the world, not because we're more violent, but because we keep choosing punishment over care, jails over services, and fear over hope. SB 457 follows the same path. It brings back harsher penalties and expands the power to lock people away, many of whom haven't been given the fair chance to rebuild. And we know exactly who that harms: Black and brown immigrant Nevadas who are already over-policed and underprotected. I've seen families shattered because of one mistake. I've seen parents miss years of their children's lives. I've seen people lose trust in the system that was supposed to help them. Please don't choose more pain over our communities. I urge you to vote no on SB 457. Thank you.
Thank you, Chair and members of the committee. My name is Olivia Tanager on behalf of the Sierra Club Toyabe chapter. For the record, the Sierra Club recognizes that civil liberties are crucial for environmental protection and a functioning democracy. We advocate for the right to vote, fair and just courts, and protecting voices from being silenced by polluters and big money. At a time when the federal government is taking steps to punish environmental organizations and folks who exercise their right to protest, we don't need to be giving more tools to target protesters, including groups like mine, as outlined in Section 65.5. Further, in the final hours of session, I can think of a much better way to expend our limited resources. As an environmental organization, we're very concerned about the hundreds of Nevadans that are probably going to die this summer due to extreme heat. If we were going to be considering policies that are going to help Nevadans, we would prefer to see policies that address issues like that instead of policies that further criminalize Nevadans. Thank you.
Good evening, Chair and members of the committee. For the record, my name is Tara Webster, Tarawebster. I'm here on behalf of the Progressive Leadership Alliance of Nevada in strong opposition to Senate Bill 457. This bill is neither evidence-based nor sustainable, and with that, we urge a no vote.
Good evening. My name is Melody Hudilia. That's spelled MELODYJUDILLA, and I'm Deputy Director of Silver State Voices. We are here in strong opposition and solidarity with our table partners. Thank you.
Good evening, Chair Miller and members of the committee. My name is Ben Innes, that is BENINESS. I am the Coalition Manager for the Nevada Housing Justice Alliance. We are a statewide coalition of grassroots organizers and community advocates that work with tenants throughout the state. Without strong tenant rights in our state, especially regarding ban-the-box protections as it relates to housing, the dangerous impacts of this bill would limit the access and attainment of housing for those who would otherwise qualify and afford it. Furthermore, any and all costs incurred by this bill, as mentioned earlier, would be better served supporting housing stability in our state. Thank you.
Not seeing anyone else here in Carson City or in Las Vegas. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Senate Bill 457, please press star 9 or raise hand in your Zoom window now to take your place in the queue. Again, if you would like to testify in opposition to Senate Bill 457, please press star 9 or raise hand now.
Hi, my name is Jamila Lewis. That's spelled Jameelah. Last name Lewis, Lewis. I'm a Nevada native and resident. I oppose this bill because of the way that partnership stakeholders weren't included. It doesn't seem like anyone, even on the different committees, are working together collaboratively to make sure that the community is safe. And if that cannot be done, this bill does not need to pass this session. Thank you so much. Goodbye.
Hi, my name is Malcolm Greer, and I'm a member of the Youth Voice of Nevada and many other progressive organizations in Southern Nevada. And I rise in strong opposition to SB 457. This bill proposes sweeping changes to our justice system that will disproportionately harm marginalized communities and roll back crucial reforms. This bill prioritizes incarceration over rehabilitation and equity. This bill may chill public dissent and disproportionately impact individuals experiencing mental health crisis. Instead of investing in treatment and community-based alternatives and upstream interventions, this bill expands primitive systems with vague standards and questionable effectiveness. Public safety is not achieved through harsher sentences. It is built through prevention, support, and equity. And I urge lawmakers to vote no on SB 457.
Caller, could you please spell your name for the record?
Yes, it's Malcolm, Malcolm.
And your last name?
Greer, Greer.
Thank you so much. Next caller.
Hello, members of the committee. My name is Paula Luna, Paula, and I'm the Deputy Director of Battle-Born Progress, calling in strong opposition of SB 457. I want to thank the chair and the committee members for allowing time for the opposition presentation. I want to echo their statements, especially those of Mr. Hasabullah, and I also want to echo the opposing testimony before me. Please oppose SB 457. Thank you.
Chair and members of the committee, my name is Gerald Mays, for the record, Gerald Mays, and I serve as the Executive Director of the NAACP Las Vegas Branch 1111. I rise in strong opposition of Senate Bill 457, not just because of what's in the bill, but because of how it was brought forward. This bill represents a deeply flawed process. It was introduced late in session, rushed to the finish line, and crafted without meaningful input from the very communities and stakeholders it will impact the most. Civil rights organizations, community leaders, and impacted individuals were left out of critical conversations that alone should give us pause. Beyond the process, the content of SB 457 is equally alarming. It is expensive. It rolls back hard-fought reforms from 2019 that aim to make our justice system more equitable and effective, and it paves the way for increased criminalization, particularly of Black, Brown, and low-income Nevadans. Provisions like corridor enforcement zones and expanded felony classifications are not justice, they're regression. These policies deepen the very disparities we've been working to dismantle. I urge this body to reject SB 457 in its current form. Nevada deserves thoughtful, transparent, community-informed legislation, not a rushed, punitive package that undermines public trust. Thank you.
Hello, my name is Adrian Lowry, Adrian Lowry. I am speaking in opposition. This bill is a step in the wrong direction, increased criminalization of a community with more members of that community in precarious economic and social situations, which leads to more criminal acts, which leads to more criminalization and a vicious cycle. The short history of mass incarceration in this country has demonstrated that this self-feeding approach has explosively increased both the number of prisoners and the number of crimes committed. It does not make us safer, and it harms the very fabric of society when entire communities are criminalized. The productive way to address crime is to build up our communities so that people are not in precarious or desperate situations. Thank you.
Hello, can you hear me? Hello?
Yes, you may begin.
Hi, my name is Yesenia Moya, Yesenia It is sine die, so why are we rushing to pass a harmful bill like this? I mean, we've heard it from the opposition, and we thank you for allowing that presentation, but this is being passed without transparency, accountability, or public input. Why are you listening to people who aren't experts, who don't carry lived experiences and offer no data? Why do you want to close access to drug court? Why do you want to keep people in jail longer? Why are you allowing the bargaining of our lives to be shaped by people who refuse to listen to all stakeholders like myself or impacted people, public defenders, advocates, families, organizations? Why was the Resorts Association allowed to amend this bill behind closed doors while the rest of us who are directly impacted were shut out? This is not public safety. This is not democracy. With Fourth Amendment violations, Second Amendment violations leading to First Amendment rights violations, this is the criminalization of poverty and the silencing of us who are most impacted. We deserve better, and you need to vote no on SB 457 because I can assure you that the community that held the lines on the phone last week and today will remember at the ballot box. Because if you pass this, we deserve better, and that's not you. There's more of us than there are corporations, and we are more than community members. We are organizers. So vote no or see you on the campaign trails.
My name is Nicole Williams, and I COLEWILLIAMS. I'm calling in strong opposition of SB 457, a poorly constructed bill that is being rushed through with no data, no transparency, and no regard for public input. It's costly, ineffective, and takes Nevada backwards. Please vote no on SB 457. Thank you.
Caller with the last three digits, 991. Please press *6 to unmute your phone. You may begin.
Chair, members of the Judiciary Committee, my name is Dallas Anselmo, DALLAS ANSELMO. I'm a Deputy Public Defender in Clark County, and I reside in Assembly District 21. I oppose SB 457 and the Corridor Court Amendment. I was on the team of public defenders that served in the original Corridor Court from its inception. First, the court is gratuitous. The state has every ability to seek orders out on cases as they see fit now. Our justices of the peace have the ability to assess these crimes without a special court. To revive the Corridor Court because we prefer cookie-cutter and robotic adjudication of our poor and vulnerable as opposed to individualized treatment for accused persons who are always unique. No testimony we've heard from the resort's representatives made an argument supporting the necessity of a single court as opposed to each justice court handling cases as they appear. Second, the Resorts Association and Metro attended many judges' meetings concerning the Corridor Court during its operation. The largest demonstration of crime my office personnel heard in those meetings included a 4% crime reduction in Clark County, not just the corridor. That's it. Corridor court proponents have had more than enough time to get you numbers, and they haven't. The casino industry wants to harp on serious crimes and the fear that comes with that. The committee asked about common crimes, and I can promise you that the overwhelming majority of crimes I personally defended in that courtroom dealt with nonviolent, quality of life misdemeanors involving poor and unhoused clients. I was in the room. These provisions target the poor. Please do not resurrect this black eye on the state of Nevada. Thank you.
Good afternoon, Chair Miller and members of the Assembly Judiciary Committee. Caleb Green for the record, CALEB-GREN. I'm the president of the Las Vegas chapter of the National Bar Association, also known as the LVNBA, which is an affiliate chapter of the National Bar Association, the largest organization of Black attorneys, judges, and legal professionals worldwide. I'll be brief. On behalf of the LVNBA, we urge you to oppose this bill. We echo the concerns of the Clark County Public Defender's Office and the ACLU of Nevada, and the opposition from Battle-Born Progress and the NAACP Las Vegas chapter, particularly the fact that this bill has evolved on an extremely short timeline. It does not allow community stakeholders time to review and provide input on this amendment. This bill needs a lot more work, and I think the representative for Resorts Association during his testimony in support of this bill admitted that the amendments are late, and it's disappointing that an amendment of this gravity is being rushed through the policymaking process with no evidence-based support, hardly any community input, and that this committee has been put in the impossible position to weigh in on this important matter for the first time with only a few hours left in this legislative session. We ask you to reject the latest amendment and allow for proper policymaking. We urge you to reject this bill. Thank you.
Caller with the last three digits, 059. Please press *6 to unmute your phone. You may begin.
Hi there, my name is Lauren Kern, LaurynKern, and on behalf of Reno and Reno's grassroots organization Sunrise Movement, I oppose SB 457. This last-minute bill does not represent the best interests of Nevada, and I echo concerns of harm against severely marginalized communities. Thank you.
My name is C. McCombs. It's spelled C, the letter C, and the last name is MCCOMBS. I would like to speak in strong opposition to the bill for a litany of issues. First and foremost, I think it flies in the face of democracy. We're seeing a situation that I can't describe as any other way than corruption, because we see financial interest being leveraged against the interest of constituency. Again, we're going to see a situation where we have, hundreds of people calling in opposition to this, and I hope that legislators see that and understand that it dwarfs the amount of people that are speaking out in support. And the reason is because this is driven by interest that is not aligned with community values. This is driven by corporate interests, and historically, we have not seen, especially in the city of Reno, that interest align with the values of keeping our community safe. As an aid worker, I can tell you personally, we've seen Washoe County jails filled up more often than not because of recent sitting ordinances. And I can assure you that this has resulted in nothing but more taxpayer dollars being thrown at a problem that simply housing could solve. And instead of putting money where it needs to be, we're talking about, supporting another crime bill that I think everyone can agree on historically has led to mass incarceration and the horrible conditions, the economic conditions that we see here today, right, for millions of thousands, hundreds of thousands, if not millions of Nevadans. And so I would like to speak strongly in opposition to this ordinance. Thank you.
Hi, Michael Beer for the record. That's Michaelbeer. Yeah, I'd just like to register strong opposition to this bill. I work in the affordable housing industry. I would love to say that I'm here representing my company, but as I only heard about this a couple hours ago, I wasn't able to talk to any of my coworkers, let alone my boss, to find out if it was okay for me to represent the company, let alone talk to other people in my industry. What I can say is that the evidence shows that if you want to reduce crime, if you want to reduce homelessness, the solution is not to jail people more, jail people for longer. The solution is housing. It's more supportive services. I seriously question why this is even up for discussion under such a rushed timeline, and I really hope that you don't let this bill go forward. Thank you.
Thank you so much. And I will take one more phone call, staying consistent with our time limits, and because I had missed an individual that's down there in Las Vegas. So last phone call, please.
Caller with the last three digits, 004, please press *6 to unmute your phone. You may begin.
My name is Sandra Valentino, Sandra Valentino. I am strongly opposed to SB 457. I have never actually felt so angry making a public comment on any other bill. I cannot believe this bill is even being entertained. The rushed nature of this bill is not an accident. It is a tactic to try and get it passed. Very clever to put child sex crimes alongside DUI, knowing that everyone hates crimes against children. This whole thing is nothing but shady. The list of crimes in this bill are too vast and should not be together. As a victim of a child sex crime, even I cannot support this bill. You are unfairly categorizing all of these together. For example, with DUI, you could arrest every single person that has ever taken a drink and drove a vehicle. You do realize that that fixes nothing. You are putting a Band-Aid on a gunshot wound. Being incarcerated does not stop anyone from getting out and doing it again. We need to fix the problem causing these actions. This bill will only cost Nevada countless amounts of money. Please vote no. Thank you.
Thank you so much, and we are still within our time, but I apologize for missing you down there in Las Vegas. So please proceed with your testimony, please.
Thank you so much, Chair Miller. I appreciate your graciousness in allowing me to approach members of the committee. On behalf of, my name is Ashley Dodson for the record, ASHLEY-DODSON. I am a policy analyst and also community organizer. In the final hours of the legislative session, we should not be advancing policy that will unjustly harm lives and deepen the iniquities in Nevada. SB 457 is a dangerous step backwards, one that will criminalize poverty, mental illness, and homelessness and push back more Black, brown, and low-income Nevadans into cycles of incarceration. This bill was rushed forward with sweeping amendments released late and no public transparency, denying the very people it impacts a fair chance to respond. Even now, the bill has not received proper fiscal review despite millions in expected costs. At its core, SB 457 is not about public safety. It is about expanding mass incarceration. It will funnel unhoused Nevadans into jail instead of services. It will strip away record ceiling, locking people out of housing and jobs. It will expand surveillance and erode civil liberties. We urge this committee, in Nevada's last hours of session, it should not be spent passing harmful rush legislation that destroys families and deepens racial and economic injustice. Please vote no on SB 457. Thank you so much, respectfully.
Thank you so much, and that concludes our opposition testimony. So I will open it up for anyone in neutral. Not seeing anyone here in Carson City or in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to testify in neutral for Senate Bill 457, please press star 9 now or raise hand in your Zoom window to take your place in the queue. Again, if you would like to testify in neutral for Senate Bill 457, please press star 9 or raise hand in your Zoom window now.
My name is Lily Barron, L-A-L-Y-B-A-R-A-N. I'm calling in strong opposition to this bill. Nothing that is worth bringing to light should be done in the dark.
Ma'am, we are not in opposition. Opposition testimony has closed. We are in neutral. Next caller, please.
Good evening, Chair Miller and Vice Chair and members of the committee. Chair Miller, my heart goes out to you and the rest of your member of the committee. I can hear the tone of your voice, and this is very heavy in your guys' heart. So we are giving you guys, prayers and hope that you all make a great decision. I'm in neutral. This is Dora Martinez. I don't know if I said my name. With the Nevada Disability. Oh, gosh. I don't know if that's a good thing. Anyways, this is Dora Martinez with the Nevada Disability Action Coalition Chair. We are in neutral because, I'm blind, and I was trying to read it, and it's not accessible to my screen reader, and I hope that LCB accessibility team will do better. And I know it's hard because this just kind of dropped, and it is not in compliance with Americans with Disability Act. But so we are in neutral, and I thank you so much for each and every one of you and everything you guys do. And take care of yourselves, please. Thank you.
Thank you so much. Next caller.
Caller with the last 3 digits, 515, please press star 6 to unmute your phone. You may begin.
Owen Brown, Owenbrown. Hi. So I'm standing in my living room right now, and there are 8 people who are also waiting on the phone.
Sir, are you in neutral?
Are waiting.
Sir, are you in neutral?
We are all in opposition.
Okay, sir,
of SB 457.
we gave 30 minutes to opposition. So I had announced at the beginning we would do 30 minutes of support, 30 minutes of opposition, and 30 minutes of neutral. So you are more than welcome to submit your comments in writing. So opposition has closed. So you may submit your position in writing. Thank you so much. Next caller. Again, on the agenda, it will give the instructions to submit your testimony in writing. Next caller in neutral, please.
Hello, my name is Manuel Ayala. I am testifying in neutral simply because this bill has been pushed so last minute. I have not been able to read anything. And I would like just to say to the committee and all the members that when voting, keep in mind on why this bill has been pushed so quickly through the Senate, or rather through the legislature. Thank you for your time.
Sir, could you spell your name?
One moment, Chair.
Yes, it's Manuel Ayala, Manuelayala.
Thank you so much.
Caller with the last 3 digits, 759, please press star 6 to unmute your phone.
Greetings, Chair Miller. My name is Jagada Chambers, Jagada-Chambers. I'm calling in neutral right now. I would love for the resort corridor crew in this last second amendment to have something pertaining to how much alcohol the resorts serve folks,
okay,
and then send them out onto our byways and highways.
Mr. Chambers,
Yes,
any request or change or amendment, actually according to committee rules, would be in opposition. So,
no, I know the opposition has closed. I was really interested in that, but I understand I forfeited my opportunity. I appreciate y'all. Hopefully y'all stand tough on this one.
Thank you so much. Next caller. And I know neutral is tough. Generally, neutral is what agencies come in and say, let me give you some more background. Here are the facts. Here's what, as an agency, we can and cannot do. I trust it's difficult, for personal positions for it to be neutral. But again, we need to try to stick to true neutrality. So with that, next caller in neutral.
Caller with the last three digits, 061. Please press *6 to unmute your phone. Caller with the last three digits, 061. You're unmuted on our end. Please press *6 to unmute your phone. You may begin.
Hello, my name is Kate, Kate for the record. I'm calling in neutrality for the Bill SB 457. I'm calling in neutrality because I didn't really have time to think about this bill. It was happening so quickly. But seemingly, it just seems like the sources cited for this bill are cop, and maybe another cop. Very evidenceless. It seems pretty sloppy, but I'm not well informed enough. Thank you.
Thank you. Next caller in neutral.
Hi, my name is Jeff. It's Jeff. I'm calling to support a neutral position on this bill. I watched the hearing session, and I just don't think that there's enough evidence to support a bill like this. I think it's being rushed through the legislature. I'm not sure why that is, but I'm definitely suspicious.
Okay, sir, is this neutral or is this opposition?
I'm neutral because I'm undecided.
Okay.
I think that there needs to be more data collected before we make a decision on this bill. And that's it.
Thank you so much.
If you have recently joined and would like to testify in neutral for Senate Bill 457, please press *9 now to take your place in the queue.
Hello, good evening. My name is Hadassah Golden, Golden. And I am in neutral on this only because I was, first of all, really surprised that this bill came forward and so quickly because we have been such a strong, supporter of Governor Lombardo. And we would like the time to really analyze this bill, for the people to examine it, and to learn more about it before this is passed. Thank you so much.
Thank you. Next caller.
Caller with the last three digits, 804. Please press *6 to unmute your phone. You may begin.
Hey everyone, my name is Maeve Moynihan, MaeveMoynihan. Sorry I'm late. I was just at an AA meeting and surrounded by a lot of people that would be affected by this bill.
Ma'am, is your testimony in neutral?
Strongly oppose it. And
Okay,
ask
ma'am,
that-
we are not taking opposition. Opposition is closed. We are in neutral. Thank you. But I will invite you to submit your comments in writing, and those directions are on the agenda. So next caller, please.
Chair, there are no other callers choosing to testify in neutral at this time.
Thank you so much. Well, with that, I will close testimony. I will invite the bill presenters up. Thank you. It is sine die, so they have waived the request to come up and make any final comments. So with that, I will go ahead and close the hearing on Senate Bill 457. I will take public comment now. So just a reminder, the same rules that we ask that you state your name and spell it for the record and keep your remarks to 2 minutes each. As a reminder, the rules of the committee are that public comment are not to make comments on any bills heard that day. It is to make comment on other issues that are under the purview of the committee, but there will be no public comment on today's bill hearing. So with that, I will begin public comment here in Carson City. Not seeing anyone. There in Las Vegas, would you like to make public comment? Also not seeing anyone. Broadcasting, please open the lines.
If you would like to provide public comment, please press *9 or raise hand in your Zoom window now to take your place in the queue. Again, if you would like to provide public comment, please press *9 or raise hand in your Zoom window now. Caller with the last 3 digits, 556, please press *6 to unmute your phone. Caller with the last 3 digits, 556, you are unmuted on our end. Please press *6 to unmute your phone. You may begin.
Anne Marie Grant, ANNEMARIE GRANT. Good evening. I'm calling today as the sibling of Thomas Purdy in 2015. Thomas was killed at the Washoe County Jail after being hog-tied and asphyxiated by Washoe County deputies. He was experiencing a mental health crisis. His death was ruled a homicide, but no one was held accountable. Nearly 10 years later, nothing has changed to prevent what happened to him from happening to somebody else. My brother didn't need force, he needed help, and the system failed him at every level. What happened to Thomas was not just a personal tragedy, it was a policy failure, a failure of leadership, and a failure of courage. Thomas's name should have meant change. Instead, we've watched the years go by with no meaningful action to protect people in custody or hold law enforcement accountable when they kill a community member. Justice reform is not about politics, it's about life and death. My family is still grieving, still waiting for justice, and still waiting for this state to care enough to act. Please don't let another family go through what we have. Nevada must do better. Thank you.
Thank you. Next caller.
Tanya Brown. Good evening, Madam Chair, members of the committee. Tanya Brown, TONJABROWN, advocate for the inmates and the innocent. We want to thank you for the hard work that you have been doing this legislative session, and as a reminder on some of the things that we have brought as advocates for the inmates and the innocent to you during this legislative session, to please bring it forward into the next legislative session. And I want to give you a heads up that there is a movement on dealing with prosecutors who withhold exculpatory evidence. And when you get back to Las Vegas, you will be seeing some signs up on the billboard regarding certain prosecutors who are running for office. I just kind of wanted to give you a heads up on that. And please keep in mind that we definitely need a factual innocence posthumous petition. I'm getting my ducks in a row, and you will probably be hearing about it very soon. Watch your news. Thank you, and have a good evening, and good luck on passing all your bills successfully. Thank you, and talk to you next year. Bye-bye.
Thank you so much. Next caller.
Caller with the last 3 digits, 477. You are unmuted and may begin. Caller with the last 3 digits, 477. You are unmuted on our end and may begin.
Can you hear me now?
Yes, you may begin. Caller, it appears you've muted yourself. Please press *6. Now you may begin.
Sorry about that. I'm having some technical difficulties here. Well, Chair, members of the committee, my name is Chandler Cook, ChandlerCooks. As this session draws to a close, I simply want to pause and say thank you. Thank you for the weight you've carried, the debates you've entered, the long nights you've endured, and the decisions you've made that will shape the lives of Nevadans for years to come. While every bill may not carry unanimous support, every vote cast is a reflection of your commitment to serve, and that service deserves our respect. So in these deeply divided times, I pray that even as you leave the chamber, you carry with you a renewed sense of unity, of humility, and of grace for one another and for the people you represent. Because at the end of the day, our strength as a state isn't measured by, how fiercely we argue, but how faithfully we lead together. So may wisdom continue to guide you, and may Nevada continue to prosper under your stewardship. Thank you.
Thank you so much.
Chair, there are no other callers choosing to provide public comment at this time.
Thank you. Then with that, I will go ahead and close public comment. A few words first. First, I would like to thank everyone who participated in this hearing, from the members to the presenters to everyone that testified, because everyone followed the rules and we were able to get through it. Such a robust, deep conversation, but within our time limits, because again, time is of the essence today, right? So I appreciate everyone being efficient, and just everyone followed the committee rules. So that was excellent. Thank you so much on that. I would also like to, often you see the members up here, the legislators up here working, and a lot of people give us a lot of, appreciations and kudos and stuff, but who doesn't get those as much is our hardworking staff. And so you see our policy analysts and our legal up here, but we also have, yes, go ahead and clap. There's actually a staff of 10 that, and again, people you may never see that work for LCB, but behind the scenes for the Judiciary Committee. And so I just always want to acknowledge them, because just like as you're watching a movie scene, you didn't realize it may have taken 200 people behind the scenes to get those 3 or 4 people in that screen or shot. So I just really appreciate all the hard work and everything that the employees of LCB does, because what people also don't realize is sometimes once we leave, like tonight when we leave the floor, which will probably be 11:59, let's be honest, they're not leaving the floor. It still takes them a few hours after we leave before they're actually finished with their work and able to leave. So just want to really appreciate and acknowledge all the hard work you do and the support that you give us all, so that we can do the work that we need to do. With that, we are in recess.